Let me share with you an awkward trial scenario. So imagine this. We're at trial and I'm using a particular exhibit that I spent a lot of money to create. And now I finished questioning the witness, and the defense attorney gets up and is about to question the witness, and he turns to me and says, "Mr. Oginski, you don't mind, I'm going to use your trial exhibit. Is that okay?" Let me share with you what the answer is. Come join me as I share with you this remarkable information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. When we get a case ready for trial, each side will have to go ahead and prepare whatever exhibits they feel is necessary to go ahead and use during the course of trial when questioning witnesses. I will tell you that many of these exhibits are very expensive to prepare. Many times we will use blow-ups, big poster boards of different types of documents, and we will blow them up so now the jury can see it from far away. Now, what happens when the defense attorney gets up and goes to question a witness, and he turns to me and says, "Mr. Oginski, I hope you don't mind, I'm going to use the exhibit you were just using." Do I say yes, or do I say no, go get your own? What happens when the defense attorney now says, "Mr. Oginski, can you turn on your projector and turn on your laptop so we can see that exhibit again so I can question and cross-examine your witness?" Do I turn around and say, "No, you can't"? How does that make me look to the jury if I turn around to the defense attorney when he asks, most of the time graciously, "Hey, can I use your exhibit to show and question this witness?" Do I say no, where now I look like I'm selfish? Or do I graciously say, "Of course you can," where now it looks like I'm doing everything possible to sort of help my adversary, but being gracious at the same time? Do you think that helps me or hurts me? The reality is that it's a really awkward situation. Here it is, I've spent a great deal of time and energy and money to put together these exhibits designed to be used for me, for my purposes. Now the defense will also do something similar. And there may come a time where I may have to turn to the defense attorney and say, "Hey, listen, can I use your exhibit? That's a little bit better than the one that I brought to court. How about we use yours?" And again, the defense attorney is in an awkward position. If he says no, he looks selfish. You know, go back to grade school. When a kid says, "Hey, can I borrow your crayons?" You say, "No, you can't borrow my crayons." Why not? You've got a lot of them. But the point is, how is it going to look to the jury if I say no? So the reality is that almost in all situations, I will go ahead and say, "Yes, of course you can use my exhibit." And likewise, when I turn around and ask the defense attorney, "Hey, can I use your exhibit?" I expect him to do the same thing. So just imagine if I've said yes, he can use my exhibits, and now I turn to him later on during the course of trial and ask to use his exhibit. If he says no, again, now the jury will look at him and question why he's not allowing me to use his exhibits. So why do I share this tidbit of information, this trial trivia with you? I share it with you because this does come up during the course of practically every single trial. And you know what? Nobody talks about it. Nobody mentions it. And I want to share that here with you today. Chances are you're watching this because you have questions about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, here's what I want you to do. I want you to pick up the phone and call me because I can answer your legal questions. This is something I do every single day and I welcome your call. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski. Have a great day.